I don't know.
Okay, good morning. It is 8:53 a.m. We're going to start a little early today. We are going to take a break at 9:45 for about an hour. And I know Mr. Hall is not feeling well, so maybe we'll get to all of your cases before the break, Mr. Hall. Otherwise, it'll be about an hour break, okay?
That perfectly fine. Whatever works for you, Mr. Hearing Officer.
Okay, and I'm sorry you don't sound well, and I hope you get better quickly.
Thank you for that.
Of course, let's call the first case 25953. Entries of appearance, please.
Jackie McLean on behalf of Mewburn.
Thank you.
And EOG has entered an appearance but is not objecting.
Perfect. Go right ahead.
Thank you. We're back today because the division requested some additional information and exhibits. Last Friday, March the 6th, we filed an amended exhibit packet that includes an amended Exhibit A3, non-standard spacing unit plat and NSP notice list, an amended Exhibit A8, which is the amended chronology of contact. We've also included EOG's letter of support as well as communications with WPX about them receiving notice of the hearing, and then an amended Exhibit C4, which are the engineer's economics and conclusions for an alternative development scenario. I asked that the division admit these exhibits into the record and that the case be taken advisement unless there are questions, which there might be.
Admitted without exception. Mr. McClure.
Mr. Hearing Examiner, I will have questions for the landman in this case.
Okay.
Okay. Braxton Blanford, and I saw he's on.
Good morning.
Good morning, Mr. Blanford. Would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you. Please spell your name.
Braxton, Braxton, Blanford, Blandford.
Thank you. And I recognize that you are an expert in the field of petroleum land matters. So, Mr. McClure, go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Blanford, if I can draw your attention to your Exhibit A-3 that starts on page 18 of 127 of the amended exhibit packet.
And I can share that.
Thank you, Ms. McLean.
Thank you, Jackie.
Okay. Is this the correct page, Mr. McClure?
Yes, it is, Ms. McLean. Mr. Blanford, was this exhibit put together by either yourself or under your direct guidance?
It was.
Is it your understanding that EOG and all working interest owners other than them in the surrounding tracts, well, let me back up. Of the tracts which Mewburn operates that's surrounding the proposed unit, is it your understanding that notice was provided to each working interest owner?
It is.
And you reviewed that to confirm it?
Yes, sir.
Following this plat here, there's a list of tracts with their working interest owners. Are you familiar with what I'm referring to?
Are you referring to the affected working interest owners and Mewburn operated tracks?
I'm referring to the exhibit that Ms. McLean is showing here.
Okay.
Can you draw my attention to where this list includes the east half of the northeast quarter of section 22? in Township 18 South, 29 East.
Can you repeat that one more time? The east half, northeast
section-
quarter?
Yeah, well, we can just, it's the east half, but it's the northeast quarter of section 22. If you can look for section 22 of Township 18 South, 29 East. This is going to be the tract that's directly west of the proposed unit.
We have the northeast quarter, southeast quarter of section 22.
Yeah, that's the kitty corner one.
It doesn't look like that one's on there. I'll just go ahead and answer.
Is that, I can't see, with where we're at on the, exhibits, is the east half northeast described as a, Mewburn operated tract?
Let me see. Oh no, the east half north, oh, wait, that's section 22. That's not a Mewburn operated tract.
Okay, let me ask a new question. Is that tract identified anywhere within this list?
Should be identified, throughout the record title that was, notified.
Here's
I see it
the,
right there for EOG, and it looks like it's going to be under numerous other parties as well.
You have it listed as record title owners. What is the status of that tract?
Can you
Is it
clarify that
leased?
question?
Is that tract leased? Is it being operated by EOG? Who's the operator in that tract is my best question.
So I'm not. Go ahead.
I was just gonna give you the map because I don't know. I don't think we have that specifically anywhere.
So I believe that is included, that section 22 is all included within a Mewburn operated unit. I didn't see where we had drilled wells up there yet, so that's why I didn't put it in operated tracks for us.
Okay, I have the same question for the north half of the south half of section 23. Who's the operator of that track? Or those tracks included therein?
Jackie, can you go back up to the plot?
Yes.
And you asked about the north half, south half of section 23.
I don't know. I guess I don't know how appropriate it is for me to be answering your question. So just let me repeat my question. Who is the operator for the north half of the south half of section 23?
So that is within the contract area for Mewburn's IOU unit. We have not yet drilled wells there. And then further, I guess it would be the northeast, southeast would be it'd be part of the EOG Terlingua well. So they operate that tract currently. And as you can see in the exhibit, they have been notified.
Who is the operator for the north half of the south half of section 24?
At this time, there is not an existing well, to my knowledge, and that it is same situation. It's included in Mewburn's IOU unit, but we have not at this time drilled any wells there.
Who is the operator of the south half of the southeast quarter of section 18?
South half, southeast, section 18. I do not I can't see the rest of my exhibit right here. I don't recall there being a well there.
South half, southeast quarter of 18.
Mm-hmm.
And we noticed EOG for as record title owners,
As well as other
as well
parties,
as
it looks
or-
like.
yes, some other parties as well.
Is it Mewborn's assertion that there are no working interest owners there and only record title owners? Mr. Branford?
I don't. I mean, I'm sure there are some working interest owners. I'm not familiar with the title in that tract.
I guess, Mr. Branford, if I were to ask you to provide me with the working interest owners for each of those tracts, do you understand what I'm asking for?
Yes, sir.
Is that even if it's not a Mewburn operated tract?
Ms. McLean, the rule, you're correct. If it's not a Mewborn operating tract, let me back up. If Mewborn is the operator of record, then notice has to be provided to the working interest owners. If Mewborn is not the operator of record, then the operator of record is who needs to be provided the notice for those tracts.
So I guess these tracks, I don't believe have an operator currently. And that's why Mewburn noticed record title owners. So is there, for those non-Mewburn operated tracks that there is currently no other operator, do we need to notice working interest owners?
Mr. Hearing Examiner, do you think it's appropriate to have the conversation with Ms. McLean about requirements and rule after I finish questioning the landman? Or what's your thoughts there?
Well, are you finished questioning the landman?
I'm not.
Oh, you're not? Okay.
No.
Why don't you finish your questions for the landman?
Okay, thank you, Mr. Hearing Examiner. Mr. Branford, it appears that you have listed, let me see if I can find the page. It appears that you have listed page 19 of 127 for the south half of the southwest quarter of section 18, township 18 south, 30 east. You see where I'm referring to?
I do. Yes, sir.
I guess I'm not seeing it completely on the shared screen, but if you see it, Mr. Branford, that's fine.
Is it
The third,
this?
I'm looking at below, a little bit below, if you want, Ms. McLean. It has the working interest owners listed.
Oh, okay, sorry.
Yeah, the very,
Okay.
or kind of the or like a third of the, or 2/3 of the way down, Mr. Branford.
Yes, I
You see where it has like number 3 listed there, Blue Star Oil and Gas LLC?
I do.
Was this person provided notice of this application?
They were.
Yeah, I
And I
guess
think
I'll
I can,
have some questions from Ms. McLean afterwards then.
yeah, I can clarify that for you, Mr. McClure.
Okay, we'll touch base with that a little bit more here in a bit. Mr. Branford, if I can draw your attention down to the next page where it's south half of section 14. The sixth
Okay.
person down. You see the WPX there, Mr. Branford?
I do.
Was this person provided notice of this application?
Yes.
Yeah, but there's probably another one I'll need additional clarity from Ms. McLean on. Thank you, Mr. Branford. I think I'm done asking questions of this expert witness, Mr. Hearing Examiner. And if I
All
could
right.
ask Ms. McLean, I guess.
Yes,
questions.
go right ahead.
Okay, thank you, Mr. Hearing Examiner. Ms. McLean, you referenced earlier that you may have additional clarity on the notice provided to Blue Star Oil and Gas LLC. What is that
Yes.
additional clarity?
Blue Star and Vladden are one and the same. They're the same entity. And what happened was on the envelope, when we were inputting all of the addresses into the spreadsheet, we had Vladden and Blue Star and then one address. Well, it just sent it to Vladden, but Mr. Blanford can also provide testimony that they are the same. He's been in contact with Vladden/Blue Star. They have the same address and they've been given notice through Vladden.
I guess, do you have additional clarity in regards to WPX Energy Permium as well, Ms.
I
McLean?
do. For WPX, oh, sorry, my share screen button is getting in my way here. If you see the, on the cover sheet, the notice of amended exhibit packet, our exhibit A8, we have included, and I'm just gonna try and get over there. We have included a email with WPX. Where's the? That shows that they were provided, oh, here it is, sorry. This is the email with, from Mr. Blanford to Andy Bennett at Devon, which is, WPX and, another entity of Devon. And, Mr. Brunsman, I guess, replies back that WPX Devon has no objection to Mewburn's NSP application in the IOU unit. So we have included that to demonstrate notice to WPX.
So was written notice ever provided to Devon or WPX?
Just via email.
Mr. Hearing Examiner, do you think it would be best for myself to ask questions of Mr. Blanford in regards to the relationship between Vladden and Blue Star, or allow Ms. McLean to just do cross-examine on that?
Well, I think you should ask the questions, and then if Ms. McLean wants to redirect, she can.
Okay, thank you, Mr. Hearing Examiner. Mr. Blanford, are you still with us?
Yes, Mr. McClure, I'm still here.
Mr. Blanford, what is the relationship between Vladden LLC and Blue Star Oil and Gas LLC?
It's run by the same person. I have the same point of contact between the two entities. use the same address for any mailings that I do. So
Okay.
notice was sent to each of the parties at the same address.
Now, Ms. McLean referenced that the envelope might have only had Baden on it. Was the contents of that envelope, did it include a letter to each of the persons or just Baden?
I think I could
I-
answer that one because we send out those letters.
Okay, that same question to you, Ms. McLean, I guess.
Yes, thank you. We send out, we don't directly address the letters to any particular party. So it was the same letter in the application.
Okay, thank you, Ms. McLean. Thank you, Mr. Blandford. Mr. Hearing Examiner, I don't think I have any further questions other than if we want to talk about required notice, I guess.
Okay, go ahead.
Ms. McLean, do you by chance have the rules in front of you by any chance?
I do not, but I could pull them up.
Yeah, I'm just looking at the definition for affected persons.
I'm pulling it up. Okay.
I'm looking at the little b for affected persons. The very start of that, in the absence of an operator.
Okay.
I guess, do you see what I'm referring to, where we would need to, well, not we, but the applicant would need to provide notice to the working interest owners in any track in which it is the operator or in which there is no operator of record. Are you in agreement with my assessment?
Yeah, I do see that. I think the issue becomes knowing the working interest owners in a track that is not currently operated. Because people don't always have title for that. And so a lot of times with NSPs, we've just been providing notice to the record title owners because we do know that.
I guess I'm not aware of any, I'm not aware, I guess, of the division having any policy of exception from this rule. I guess, is it correct that operators tend to either employ landmen whose job it is to look for these records, or hire third-party consultants to do so?
I mean, I'm not an oil and gas company or landman. So I don't know. Um,
This is how I'd like to proceed. So, Mr. McClure, it sounds like you need additional information before you can approve or deny this application. What is it that you want from Ms. McLean and from Mr. Blanford?
If Ms. McLean, if we can go ahead and submit an amended exhibit A3 in which Mewborn provides the working interest owners for each of those tracks. I guess if Mewborn wishes to ask for an exception from this rule, I guess you could also ask for that. Somewhere in there, add a supplemental exhibit where you're asking for that. I don't know what our thought process would be and whether we need new notice in regards to that. In addition to that, if you do end up needing to update your notice or conduct new notice, then we'll need to go ahead and take care of that to cure notice. Do you understand what I'm asking about curing notice, I guess?
yeah, so I just want to make sure that
Mhm.
I understand exactly what you're asking for. So on the current exhibit A3, any tracks that are not listed as Mewburn operated, you want a list of the working interest owners.
Let me back up, I guess. I need the operator of record for each of the surrounding tracks. I believe you currently have that, but I need what I need, the final exhibit needs to have either the operator of record for each track, or if there is no operator record, or the track is operated by Mewborn, I need the working interest owners for that track.
Okay.
And then I also would like Mewborn to review its notice and confirm that notice was provided to each of those working interest owners. And if not, then notice will need to be cured.
Okay.
All right, is there anything else, Ms. McLean?
Not for, and then how should we let you know? Should we just email the division and let you know that, okay, we'll email the hearing examiner and let him know that notice has been provided to everyone, because I'm assuming it's probably gonna be the same people around there. And then we will submit that amended exhibit packet. And do we need to come back again?
Don't know yet. Let's
Okay.
wait until you find out what you find out.
Okay.
You let me know. Please copy Dean on the email and copy Freya as well. And we'll take it from there. Hopefully you
Okay.
won't have to come back, but no
Yes.
one knows. All right. Is
Okay.
there anything else, Ms. McLean?
No, that's it. Thank
Anything
you.
else, Mr. McClure?
Nothing from me, Mr. Hearing Examiner.
All right, thank you.
Thank
And
you.
when you do provide an amended, please cover page, the whole nine
Yes,
yards. Thank
yes.
you very much.
Thank you.
All right, we're off the record in that case. Let's get back to our docket. We had two NOVs from a couple of weeks ago that we are coming back on. Let me open up that now that I have an internet connection again. I'm calling case numbers, gosh, I can't see them. Hold on. 25894 and I'll do them one at a time. 25894. Entries of appearance, please.
This is Jesse Tremaine for the New Mexico Oil Conservation Division.
Good morning, Mr. Tremaine. Do we have the respondent?
Yes, Your Honor. Mr. Hearing Examiner Frank Lyon for Grand Banks Energy.
Yeah, Mr. Lyons, once again, I can't hear you. Either something's wrong with your mic or the volume's not turned up. So please say it again very loudly and right next to the microphone.
Point of order, Mr. Examiner. Mr. Lyons, in the next case, you called 29895.
I did.
You did. That's,
Right.
apologies.
Mr. Mullenberg? No.
I got you.
Yeah, sorry about that. I got mixed up on the case numbers too. Dal Mullenberg from Gallagher and Kennedy for Buckeye Disposal.
Okay.
I messed it up. My
No,
apologies.
Buckeye is 94, so we're good. So it is
Okay.
Mr. Mullenberg. So everything's fine now. Good morning, Mr. Mullenberg. I can hear you clearly. Mr. Mullenberg, where are we on this case?
Mr. Hearing Examiner, Mr. Tremaine and I have exchanged some messages. And from Buckeye's perspective, I think this case is ready for you to go to an order. It's possible that there may be a couple of points that Mr. Tremaine and I need to discuss. And if that's the case, we can figure out how to pass that on to you. But otherwise, I think I don't anticipate this case settling before it goes to an order. So if you have any questions about that, let me know. Otherwise, I think that's where we're at.
I don't have any questions for you, Mr. Mullenberg. Mr. Tremaine, how do you want to proceed?
I agree with Mr. Mullenberg. We have discussed the case in the intervening week and a half. We don't believe that we're able to settle unless something shifts substantially. So we would move forward with a request for findings of violations, issuance of the civil penalties, any other sanctions listed forth in the pre-hearing statement. When we were at hearing last, Mr. Garcia, the technical examiner, did ask for some clarification on that. I'm on a list of the sanctions requested. I did not provide that. We were having some of these discussions as of yesterday. So I'm happy to follow up in that format or submit a proposed order, or however the hearing examiner wishes to proceed.
Okay, I'm not sure how Mr. Garcia's requests work in with the final order that I have to review before sending to the director. So I'll leave that between you and Mr. Garcia to work out. And how long will it take for you to provide a proposed order?
In a vacuum, I have a major filing due next week. So I would ask for the end of the week after the 20th. So I'd ask for the 27th.
Perfect. 27th is fine. Would you pass the order by Mr. Mullenberg so he can approve it as to form before you send it to me?
Yes.
All right, fantastic. Okay, Mr. Mullenberg, anything else before we go off the record in this case?
Nothing more. Thank you very much.
All right, Mr. Garcia, is there anything from you?
Nothing at this time.
Thank you, Mr. Garcia. All right, we're off the record in that case. Let's call 25895. This is Grand Banks Energy. Entries of appearance, please.
Jesse Tremaine for the Oil Conservation Division.
And Frank Lyon for Grand Banks Energy.
Okay, I guess we're not going to be able to hear you, Mr. Lyons. Do me a favor and try raising your voice louder and tell me where we are in this case.
All right, I'll try to talk louder. My microphone shows it's turned up as loud as it'll go. Can you hear me now?
I can, yes, go right ahead.
All right, so Mr. Tremaine and I have worked out a settlement agreement that I believe is final, and it provides that basically Grand Banks is going to cease being an operator and turn over all of its available cash to the state, which is going to be in the neighborhood of $375,000. And then if we can sell a property in Texas, there'll probably be another $40,000 or so.
Okay, thank you, Mr. Lyons. Mr. Tremaine.
I agree with Mr. Lyons' description. We have hammered out what I believe to be a settlement in the best interest of the state, given the fact pattern on the ground and operators' financial situation. I appreciate Mr. Lyons' efforts in moving this along since he's joined the case. We haven't submitted that yet. We're just waiting on final signatures. I would suggest that we vacate the hearing. I don't believe that having another date set is necessary or helpful to move this along. I think we're going to have this turned around in a day or two. And I'll file the formal motion with a copy of the order.
So procedurally, we didn't have a hearing 2 weeks ago. We basically had a status conference. The parties advised the hearing bureau and the division that they were close to an agreement, and it sounds like they're closer than they were before.
We are, I believe, imminent. I'm waiting on wet ink.
Okay, so in other words, you have a settlement in principle, and you're just reducing it to a writing and signatures.
I would say we have a final settlement in specificity. Yes.
Okay, perfect. If for some reason it doesn't move forward, Mr. Tremaine, please let us know so we can get it back on the next NOV docket to hear it on the merits.
Absolutely.
All right. Well, good luck, Mr. Lyons and Mr. Tremaine. We're off the record in that case. Let's try to get some of these of Mr. Hall's cases done before the 9:45 break. I'm going to call 25920.
Thank you, Mr. Hearing Examiner. Michael Hall on behalf of New Mexico Oil Conservation Division, present and ready to proceed.
Thank you, sir. Do we have respondent Action Oil with us? Mr. Hall, was Action Oil given notice of today's hearing?
They were, according to the information, both electronic mail and address provided to OCD. However, both of those came back undeliverable. And so, yes, proper notice was provided. However, I can't say that they're aware of the hearing because they have not updated that information in a manner that OCD apparently can give them information.
Okay, Mr. Hall. And since we have a bunch of cases and this may be the fact pattern for more than just Action Oil, if you just tell me that, yes, they were provided proper legal notice under due process, then I'll just assume that what you said applies to other parties. So how do you want to proceed? How do you want to proceed in this case?
In this case, we have provided affidavits and evidence, namely exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement. We would move for admission of those.
Okay, they're admitted without exception and there is no objection. Continue.
Thank you. This is a case with one well that we need an order that OCD may have plugging authority for that well. In addition, a $450 civil penalty.
Okay. So are you, is there anything else that we need to do during the evidentiary part of this hearing?
Not that I'm aware of, Mr. Hearing Officer.
All right. Then are you going to provide a proposed order?
Yes, happily.
All right. What's a reasonable time frame?
I have the same time frame as Mr. Tremaine, so I would also, and there may be several of these, but approximately March 27th would work for me.
Okay, perfect. Then that's what we'll look for. Thank you. We're off the record in that case. Let's call Bill L. Miller. This is case 25921.
OCD's present and ready to proceed, Your Honor.
Thank you. Is there anyone here representing respondent Bill L. Miller? Okay, please proceed, Mr. Hall.
Well, Mr. Hearing Examiner, I believe Mr. Roy Bain may be the registered representative of Bill Miller, and he is present.
I didn't hear anything. Mr. Bain, do you know how to unmute your microphone?
There we go.
I
Okay.
did it. Roy Bain for the Bill Miller issue.
Okay, perfect. All right, very good.
Sorry
your
about
relation-
that, sir. I couldn't get my computer to work.
All right, Mr. Bain, for the AI transcript to be able to record what we're saying, please wait until I'm done and I'll wait till you're done. What's your relationship to Bill L. Miller?
I don't know what you would call it. Purchased his leases.
Are you a successor in interest?
I was a pumper for him, and then he decided to get rid of him, and we went into talks about it, and then he passed away, and I finished off with his wife to take possession.
Okay, so you're the responsible party for these wells.
Yes and no.
Okay, fine. Legally, I won't go any further with that. Mr. Tremaine, Mr. Hall, please. So let me ask a few more questions. So Mr. Bain, have you been provided with the notice of violation?
Yes, sir.
Okay, very good. And you obviously were given the date and time of today's hearing. Do you admit to the violations?
I guess I have no choice but to, but from what I understood, Bill had taken care of all that. But as I'm finding out, it was not taken care of, sir, and I did not know that.
Okay, and that's fair. That's fair. Okay, Mr. Hall, how do you want to proceed?
Mr. Hearing Examiner, if I could just ask Mr. Bain a couple of follow-up questions, I think only a couple. I think we may be able to clear this up and resolve it.
Go ahead.
Thank you. Mr. Bain, you and I have spoken before, correct?
Yes.
And is it correct that you told me that the one well that's subject to this NOV, you told me that paperwork had been provided to the Bureau of Land Management, in other words, a federal entity?
Yes, sir. Yes, sir.
Okay.
Go ahead.
And are you in agreement that you or your predecessor in interest did not provide paperwork seeking approval of plugging of the well from OCD, nor did you submit paperwork showing the well had been plugged to OCD?
No, sir, I did not. I do not know what Bill sent. I have no clue. I have no access to it, nothing like that. So I don't know what was actually done. So
Sure.
I'm kind of at a loss on this.
Okay. And so would you agree that as an operator, you're required to provide the proper paperwork regarding plugging to OCD?
Yes.
Okay.
Yes.
And you don't know if that's happened.
No,
do you
sir.
have any reason to dispute? Are you aware of Mr. Jackson's affidavit that he filed in this matter, wherein he said that that paperwork was not submitted?
I believe I have a copy of it. I mean, I don't know. Like I said, I didn't know nothing about it until, I got stuff from you the other day. So
Mr. Hall, hold on just a second, okay?
Sure.
So Mr. Bain, let me explain what's going on here, because I think it's important for you to understand what your rights are during this evidentiary hearing. And I'm going to need to take a break at 9:45, so I'm just letting the parties know that we may have to come back on the record in a little bit. But anyway, Mr. Hall, you've been provided with an NOV. The NOV basically says to you, there are certain violations that you, as the successor in interest to these assets, are liable for. You have the right to present evidence at this hearing. And if you need a continuance because you have not understood your rights and you want to get a witness, or you have documents or something to show that the allegations are not true, I will give you that time to do that since you have showed up. However, if you have read through the notice of violations and you weren't aware of the violations, but now you are aware of them and you don't have any evidence that shows you're not liable for the violations, then we can proceed today. You also have the right to cross-examine the witnesses that the state provides in this case. So in this case, there are actually 3 or 4 witnesses. I don't remember how many there are. And you have the right to cross-examine them to see whether, what they're saying is factually correct or not. And so you have that right as well. So I wanted to make sure you understood your rights before we proceed any further.
Okay, I don't know. I'm still lost in all this.
Mr. Hall, what are the allegations?
The allegations are Bill L. Miller has one inactive well, which needs a plugging order. Mr. Bain has represented to me that it has been plugged. However, that paperwork has not been submitted to OCD. We have also asked for a $450 civil penalty. So
Right.
that the allegations are that either
Okay,
through
I heard.
okay.
I heard, Mr. Hall. And Mr. Hall, is there a paperwork requirement here that hasn't been met? Is that the idea?
Absolutely.
All right. So, Mr. Bain, did you hear that?
I did. And like I said, I didn't know that this paperwork wasn't filed.
That's okay, Mr. Bain. We're not disputing whether you knew it or not. The question is, if the well is plugged and you haven't provided, or someone hasn't provided the paperwork to this division, then they must do so. It's a violation of the law not to do that.
I understand that, sir. I just, nobody, I don't know. Like I said, I thought it was all done, taken care of, over with, and forgot about, and then this all pops up again. So
Mr. Bain, is it your contention that the well in question, the single well in question, has been plugged?
Yes, sir.
And you know that for a fact?
Yes, sir. I have been on location.
Okay.
In fact, just a little backstory here. BLM called me about it, sent me notice on it that the well hadn't been cleaned up. Still had to pump jack in the tank, stuff like that on it. And I said, well, okay, I didn't know this because, like I said, Bill plugged it prior to me taking possession of the other wells. So he told me, he says, well, how do I get a hold of Bill? And I said, in the graveyard. So I went, cleaned it all up. As of the 18th, 4/18 of 22, I had it cleaned up. And
Mr. Bain, can I interrupt you for a moment?
Yes.
When did you buy this well?
That's what I was looking, sir. That's what I was trying to find through here.
General, a month, a year? Is there a general year or month that you can point to? It doesn't have to be an exact date.
I want to say it was in August of 20. No. December of 21.
Okay, now let me ask you another question. Do you know when the well was plugged? Was it before or after you bought it?
Before.
Before
it was plugged. I'm thinking, and like I said, I don't have anything to document it, but I want to say it was May of 21.
Okay, fine. So then you bought the well after it was plugged, is what you're telling me.
Yes.
Okay, now you're not under oath, so this isn't evidence. But you are. There is a yes. Okay. So So, I mean, I guess it might be. Anyway, do you know what company plugged it?
From what I can remember, it's BCM. The Undertaker is what they called it, and now it is called JMR. I believe, sir.
Okay.
Because when I googled BCM, it brought me to JMR Services out of Midland, Texas.
Okay, all right. Hold on one second. Let me think about that. That company may have the records.
Well, that was my thoughts was going to try to get a hold of them and see if
Okay.
they knew by chance.
Okay.
Mr. Hearing Examiner, could I
Yes, Mr. Hall.
interject for 1 second?
Yes, go ahead.
I just want to share your position that we're happy to grant a short continuance. If
Perfect.
this is a paperwork issue,
Right.
we would like to get that resolved
Perfect.
and in the spirit of administrative economy. So I just want to make that clear that OCD doesn't object to that.
All right. So, Mr. Bain, here's what we're going to do. Because you did appear and you are trying to, I believe you're being truthful so far. And it seems like we may have a way to work this out with you without having to go further. We're going to continue this case for 1 month. We have another docket on April 15 that we're going to hear more notices of violation. So I'm going to give you a month to work with Mr. Hall. Do you have Mr. Hall? Like, obviously you've been in contact with Mr. Hall. So
Yes, sir.
I'm going to give you a month, and then Mr. Hall, in a month, please have this case continued to the April 15 docket. We'll put it on the first one of the docket. So Mr. Bain, it will be the number 1 case we call that day. So you won't have to wait to hear other cases. And then we can see how we're going to proceed at that time.
Excellent. Happily. And I don't need till the 27th for that. I'll get that out to Mr. Bain and yourself shortly.
I'm not sure. What did you mean by the 27th? I didn't understand that.
Sorry, that's the date we were talking about on orders. I can get a motion for continuance and an order to you.
You don't need a motion to continue. It's already continued.
Oh, very good.
Yeah. The case is continued. And Mr. Bain, thank you for appearing today. Yeah, it goes a long way when you appear, and especially when you try to be truthful and helpful. So thank you. We're going to be off the record for the next, I'm going to say 1 hour. So we'll come back at 10:45 and continue the NOVs. Thank you.
Thank you. Mr. Bain, call me or email me, okay?
Okay. Well, like I said, am I done? Do I need to come back or?
No, you don't need to come back until the 15th of April.
15th of April. Okay.
But get in touch with me before that, okay?
Oh, I will
All right.
probably be tomorrow, bud, if that's all right. If you're not busy tomorrow.
Perfect. Give me a call tomorrow.
Okay.
Or
I
an
hope
email.
you get.
All right.
I hope you get to feeling better.
Thank you. I appreciate that. Talk to you soon.
Talk to you soon.
It is 10:40 a.m. We're back on the record. Mr. Hall, are you with us?
Yes, Mr. Hearing Examiner.
All right, we're going to call case number 6 on the docket. This is Oil Conservation Division versus Barry D. Lee, DBA Barry D. Lee Investments. Entries, please.
Michael Hall on behalf of OCD, present and ready.
Perfect, thank you. And do we have a representative from Barry D. Lee? Mr. Hall, have you had any communication with Barry D. Lee?
So, excuse me, I'm just shutting my door here. I received, I believe it was last Thursday, after I filed the pre-hearing statement. I don't know, it's not a person associated on OCD permitting, but someone by the name of Charity Lee. And in fact, I saw that name pop up on one of the screens in the earlier session today. So the answer is yes. I received a short notice last Thursday.
Okay, and when you say you received a short notice, what do you mean by that?
I will read it to you.
Oh, okay.
It says, notice, to whom it may concern. Barry Lee Investment was closed in 2023 due to hardships caused by events of state shutdown policies, which caused support businesses in the region to also be closed. Many support businesses also closed during the COVID-19 pandemic. During that time, the Department of Interior, BLM/ONRR, took control of the cash bond held for operations. With the addition of accrued fines, penalties, and interest, the operations by Barry Lee Investments were relinquished to the Department of the Interior, BLM. Also,
Okay, thank you.
Sure.
Okay,
There's
I
a
get the
little
point.
more. Yeah.
That's okay.
Okay.
I get the point. So how do you want to proceed with this case?
Well, and I just noticed, Mr. Hearing Examiner, that someone now it's not Charity Lee, Barry Lee popped up on the screen.
Yes.
So I would like to proceed seeking, I believe this is one well, seeking, or 6 wells, excuse me, that are out of compliance, seeking a plugging order and civil penalties.
All right. So, Mr. Lee, are you with us?
Yes, I am here.
Oh, you are there. Okay, very good. I called this case. Did you hear me call the case?
No, we were just a minute or two out, I guess.
No worries, no worries. I'm going to call the case again. So hold on one second. Let me find that document here. Okay, I called State of New Mexico Oil Conservation Division versus respondent Barry D. Lee. It's case number 25923. And I asked for entries of appearance. So are you appearing on behalf of Barry D. Lee?
Yes, I am.
Okay, perfect. And would you state your name?
My name is Barry Dealey.
All right, thank you, sir. Did you receive the notice of violation?
Yes, by email.
Okay,
Yes.
very good, very good. Okay, so do you know why we're here today?
Yes, I have 6 wells that the OCD is, I guess, put me under notice of violation, which I am. Yes. So.
Okay. All right, very good. So let me just explain why we're here today. We're here today for an evidentiary hearing, and what that means is you have the right to cross-examine the state's witnesses, and you have a right to present your own witnesses or evidence as you see fit to disprove the violations. Do you understand that?
I understand.
All right, very good. So let me start. Do you have any witnesses?
No, I do not.
All right, very good.
I do not refute the claims.
Oh, okay, very good. All right, so then you admit that the violations occurred. Okay. Did you happen to see the civil penalty?
Yes.
You saw that too. Okay. And what do you have to say about the civil penalty?
Just I'll put you in line with the BLM. They've got me for like 6 million. So.
Okay, I understand now. Okay, very good. All right. So, Mr. Hall, do you want to enter your exhibits into evidence?
I'm Yes, I would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Okay, Mr. Lee, have you had a chance to review those exhibits?
Yes, I'll admit the exhibits.
Okay, very good. So, Mr. Hall, your exhibits are admitted without objection.
Thank you.
Mr. Lee, did you have a chance to discuss this case with Mr. Hall?
No, I have not.
Oh, okay, all right. Do you think there is any point in trying to reach some sort of a voluntary settlement in this case?
With the LCD, no, sir.
Okay, I didn't think so. I just thought I'd give you the opportunity to put that on the record. Okay, so Mr. Hall, do you want to draft a final order in this case?
Yes, Mr. Hearing Examiner.
All right, very good. So Mr. Lee, basically, we're done. The only evidence that came in during the evidentiary hearing was, of course, the exhibits that the OCD sent to you. And there was nothing to refute those exhibits. So now what the process now is that Mr. Hall will draft a final order. And Mr. Hall, are you going to send Mr. Lee the final order so he can see it?
Yes, I received an email from a charity, Lee, and obviously I have the information in OCD permitting. I would just ask that Mr. Lee, if there's a better address, inform me of that.
No, that's fine. What you have is fine.
Okay.
Okay. So, Mr. Lee, is there anything else before we go off the record in this case?
Only that you can look at my record in the past and stuff before all the things, and I had plugged mini wells, 5 or 6, I believe, during the previous years as an operator, but that's nor here nor there. So,
yeah, your character is not in question here, Mr. Lee. It's just the question is, were there violations? And if so, what is the civil penalty for those? And so that's really the only issue here before me today.
very well.
All right. Well, Mr. Lee, thank you for participating, and I wish you the best.
Thank you.
All right.
Thank you, Mr.
All
Lee.
right. Yes, sir. We're off the record in that case. Let's move to number 7 on our docket. This is the Oil Conservation Division versus respondent B2J. Entries, please.
Michael Hall on behalf of OCD, present and ready.
Thank you, sir. Do we have anyone from respondent B2J? Not hearing anyone. Mr. Hall, please go ahead.
Yes, we would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Admitted without exception.
Thank you. And I will be happy to draft an order, but yes, we're seeking the relief set out, namely plugging order on the 3 wells operated by B2J, as well as a civil penalty of $1,350.
Okay. All right. Well, if there's nothing else, then we're off the record in that case. Let's move on to Oil Conservation Division versus respondent Black Mountain Operating. This is case number 25925, number 8 on our docket.
Michael Hall, present and ready on behalf of the Oil Conservation Division.
Thank you, Mr. Hall. Do we have anyone from Black Mountain Operating? Mr. Hall, had you ever communicated with Black Mountain Operating? No, you have not.
I don't believe so, unless there's something I don't recollect.
Okay.
I don't believe I have.
Okay, please proceed.
Yes, would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Okay, those are admitted without exception.
Thank you. We'd seek a plugging order on the 1 well operated by respondent, as well as a civil penalty of $450.
Okay, thank you, Mr. Hall. We'll look for your proposed order in the coming weeks. We're off
Yes,
the
sir.
record in that case. Let's go on to case number 25927. That's the Oil Conservation Division versus Respondent C and D Management doing business as Freedom Ventures.
Michael Hall on behalf of OCD, present and ready to proceed.
Thank you. Anyone from Freedom Ventures? No. Okay, Mr. Hall, I'm going to ask you the same question, so you might as well just tell me, have you ever communicated with anyone from this organization?
Don't believe
No.
so.
Okay, very good. Please proceed.
Yes, would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
They're admitted without exception.
Thank you. This operator operates 7 wells, all of which are inactive under the rules. So we would seek a plugging order for all 7 wells, as well as a civil penalty of $3,150.
Okay. We'll
Nothing
look for
further
that.
from OCD. Yep.
Okay, fantastic. Thank you. Let's go on to the next case on our docket. This is Respondent Caprock Exploration, case number 25929. Entries of appearance?
Michael Hall on behalf of OCD.
All right.
Present,
And is there
ready.
anyone here from Caprock Exploration? Has there been any contact with this organization?
There actually has. This one's a little different, Mr. Hearing Examiner. They have been extremely responsive. It's my understanding that the former operator has passed away. They have already paid the $450 civil penalty and are in the process of finding a plugger is what they've represented to me. So I want to commend Caprock for that. I did reach out and ask them for an update on that and whether they needed more time. I did not hear back on that. So OCD wants to acknowledge the payment of the $450 civil penalty associated with this NOV. We do seek a plugging order, but we're hopeful that Caprock can continue the process of finding their own plugger and OCD won't be forced. However, we would ask for a plugging order in the event the state is ultimately required to plug that well.
Okay, Mr. Hall. So will the proposed order still be in the general format of these are the violations, here is the evidence, and here is the proposed resolution and remedy?
Yes, other than I would acknowledge payment of the civil penalty and not ask for any further funds from this operator.
Perfect. Okay. Anything further on this case, Mr. Hall?
I don't know if I offered exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement. If I did not, I do so now.
Okay, and I don't remember if you did or not, but if you did, I would have admitted them without exception, as I am now. So thank you, Mr. Hall. Good catch. We're off the record in that case. Let's move on to Chestnut Exploration 25930.
Michael Hall on behalf of OCD, present and ready to proceed.
Thank you. Do we have anyone from Chestnut Exploration? Mr. Hall, have you communicated with Chestnut Exploration?
I don't believe so, Mr. Hearing Examiner.
Okay. All right. Well, I'm not hearing anyone here today, so why don't you proceed?
Sure. We would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Okay, and they're admitted without exception?
Thank you. Yes, the relief we're seeking is a plugging order for all 3 wells which are inactive, operated by Chestnut, as well as a civil penalty in the amount of $1,350.
Okay, thank you, Mr. Hall. We're off the record in that case, and now we're on our final case, number 12, on the docket, 25941. This is Oil Conservation Division versus Respondent Collier Pet Corporation.
Michael Hall on behalf of OCD, present and ready to proceed.
Thank you. Is there anyone from Collier or Collier Pet Corporation? Mr. Hall, any communication with these individuals?
Don't believe so.
Okay. Then please proceed.
We would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement in this matter.
Okay, they're admitted without exception.
Thank you. This operator has one well, which isn't active. We seek a plugging order for that as well as a $450 civil penalty.
All right, Mr. Hall, thank you. Okay, we're off the record in that case, and that completes our docket for today. Is there anything further, Mr. Hall?
No, thank you for your attention to these matters.
All right, and thank you for yours. Have a good day.
You too. Thank you.